passport and visa,
Yes.
but they want to apply the same term for in case of NOC also.
No,
For
home loan.
home loan.
Home loan.
Where is the mention of home loan in this circular?
Nowhere.
No mention.
Nowhere. Initially, they wrote a letter.
Para 1, it has been mentioned.
Yeah.
In para 1, my lord, subsequently, next para 1, employees apply for NOC from the corporation as employer for various reasons such as passport, visa, HFL loan, that is housing finance.
Which page?
This one, para 1 of the circular 3/11/2016. HFL loan, that is housing finance loan. Education loan, PF withdrawal, etc. in respect of passport alone, identity cum no object certificate is issued as per guidelines of Government of India. Ministry of External Affairs, which stipulates that all central government employees, state government employees, employee of statutory body and public sector undertaking shall produce an identity certificate while submitting application for passport. HFL means housing finance.
Good. Then go ahead, going ahead with that. Employees applying for NOC for corporation as an employer for various reasons such as passport, visa, SFL loan, education loan, PF withdrawal in respect of passport alone. Identity cum no objections certificate is issued as per guidelines of Government of India, External Affairs, which stipulates all central government, state government, and so and so shall produce certificate while submitting application for passport. But it has not said anything for SFL when they can detain, when they can refuse to issue a NOC. Because the headline says it is all about my lord passport and visa. This will have to be read with the next annexure also. It is also passport and visa. And here it makes a reference dated 1910-2015 circular. And also 3/11/2016 circular, the previous one, page 81. Which is at page 8. So reading together, my lord, it doesn't say both these circulars that you can detain, you can refuse to give a no objection certificate for a house loan on the grounds, my lord, mentioned in clause paragraph 2 of 3/11/16 circular. Adverse views should be taken unconcluded action initiated cases. Whether they are meaning thereby, it is this particular writ petition, which is unconcluded action initiated cases, they may mean it.
No,
But
Mr. Barba, I see the purpose of listing the writ petition may not be to hear and dispose it of today. The purpose is to see what really is the matter here. So that is why I am asking you, what is the issue in the writ petition?
I am coming to writ petition. So this I am, my lord, pointing out. What I am submitting, that irrespective of the outcome of the writ petition, they are bound to give the loan. Because after all, suppose my punishment stays and the writ petition is closed, I don't stand as a dismissed employee. What is the punishment? One week taken and recovery of rupees 60,000. All right, I bear that punishment. They will have to give
Recovery of rupees 65,000.
1,000. That is the punishment on me. Now, my lord, I'll be happy enough to argue the main case.
No, we'll not decide it. We'll decide this IA now. The purpose of calling for this record is to see what is the angle here.
Yes.
So if that is 2 increments and 65,000, then why are you withholding?
Kindly consider my page 6 of my affidavit, my lord, para 7. That this is the reason only.
Para 7.
7 of my affidavit in IA.
No, this reason is totally arbitrary and irrational.
And the first letter, my
He is an employee under your department.
My lord, that is there. My lord, para 7, my lord, lordship may decide the IA considering para 7.
I pass. Tomorrow affidavit to question.
No, sir.
Oh, it will. Tomorrow affidavit.
Oh. This is the only reason.
ইয়াতে এটা কেছি লব সুবিধা হ'ব আপোনাৰ
No, no, no.
And where is the penalty, order of penalty in the writ petition?
My lord will find that in writ petition, my lord, annexer.
Hmm.
Penalty order is at my lord. Page
Page
50. Page 45 to 50. Actually, inquiry officer, my lord, said have person not proved. Then disciplinary authority disagree. I would have happy to come to the merit. But it may not be possible to. Para 50 of the writ petition, the order.
No,
All right.
merit you can, but then point is today it's
That's
a
it.
half day court.
That's right.
If you want a final disposal, we can have it next day after tomorrow then.
Or I am agreeable, my lord, day after tomorrow Friday, but the one thing is here.
Hmm.
All right. Take this punishment, page 50. Take this punishment, my lord, page 50. Now, page 50 of the writ petition,
Yes.
the operative portion of the my lord. Now therefore, I, the disciplinary authority by virtue of power vested under so and so staff regulation, read with thereto, order that penalties of reduction by one stage in the time scale of pay applicable to her cadre and recovery of rupees 66,000 be and is hereby imposed on Srimati Rupali Bhattacharya. Now suppose your lordship dismisses my writ petition. I stand with this. I pay, I undergo this punishment.
Hmm.
Does it mean that they can refuse my SFL loan? That is the question. My terminal benefit lying right now with them is 3 times more than the loan that I am applying for. I cannot get away by not repaying the loan. So if that direction, and lordship kindly see the first letter, your lordship found fault with the language. My initially, they withdrew my lord debt. First letter of my IA, my lord. Page 11. No, page 13. 15 letter at extra 5. IA, this was the first letter.
Hmm.
I mean, they don't have any consistent, my lord, stand about giving in NOC. The first letter, it was 5/1/23, they said issue of NOC. In lieu of your pending case before Honorable High Court Guwahati, the competent authority has advised you to obtain the view of the Honorable Guwahati High Court. Then I think that the lordship will remember. Lordship was about to call that man to be in person here. So they immediately withdrew it, and these three, banking on these 3 circulars, now till today, my lord, they are denying the NOC, as a result of which the installment that I owe to pay, I owe to the builder, I will be fronting on that. So there, I pray that a definite direction may be given, my lord. They are dilly-dallying with the loan application NOC.
So they are saying clause 2, Roman 1 and Roman 2.
Yes,
How this Roman 1 and Roman 2 is applicable, attractive?
I don't understand, my lord. Adverse views should be taken
My lord,
in unconcluded action initiated case. That is where charge sheet has already been issued. Then, my lord, disciplinary proceeding is complete.
How Roman 2, 1 and 2 are attracted here?
No.
my lord, the page 8, internal page 8 of my affidavit, the 3/11/2016 is the circular letter.
Yes.
There are para 2(1).
Hmm.
Para 2(1) is the no objection certificate shall not be issued in cases where a vigilance angle is pending against an employee or a case involving vigilance angle where there is prima facie involvement in financial impropriety or someone has perpetrated a fraud or on corporation or committed acts involving moral turpitude or breaking the law of the land. That the interpretation is that, my lord, because the penalty was implemented, but penalty has been stayed by this honorable tribunal. So, my lord, the decision with regard
So
to,
are you saying that supposing the writ petition is dismissed, she will never get a loan? She will continue to remain an employee, but will never get an NOC for a housing loan. Is that what you're saying?
no,
Then,
because, my lord, this is the language of here, because it is stay.
Hmm.
So if it is dismissed, then, my lord, they will consider it.
I am asking you a very simple question.
Yes,
Mr. Nath. Whatever you answer, I am going to record it.
My lord,
Please think and answer.
only my
I am
concern.
saying
My lord.
this punishment of reduction of 2 increment and recovery of 65,000 odd rupees. Assuming that as he is projecting,
My lord.
that court dismisses the writ petition. She continues to be an LIC
Definitely.
employee like any other employee.
Definitely.
She will never get a NOC for.
My
household.
humble submission, she is entitled to get.
She is entitled.
Entitled to, because she has sufficient number of security money.
Then give
With
it
regard to
to
the provident fund.
That's it.
Our condition is that only because that is what my lord in I affidavit para 7 I relied on.
Hmm.
Because they are the, because if your lordships direct, because they are, because it's a policy decision, nobody is taking the risk that we will give any NOC. So that is what my lord para 7, I quoted that para 7 to be considered. And as per your lordship's orders, will comply.
All right, heard Mr. S. C. Borwal and senior counsel assisted by Miss. What is her name? Your Miss? Huh?
And they.
And they.
And
And they.
And
they.
Counsel appearing for the applicant. This
Rona.
order is to pass in IS civil 254 of 2023. Also heard Mr. S. Nath, learned counsel representing the opposite parties, bracket LIC. Authorities, bracket close. You are with him? Yes. The applicant is an employee of the LICI, and is presently posted at
my lord, present is
Dispur
Dispur branch of the LIC,
Dispur branch
branch of the LIC.
Dispute
of
branch
the LIC
of the LIC, my lord.
as what, as
As a my lord, SFA. Head assistant.
Higher grade assistant.
Higher
Higher grade assistant.
higher grade
Assistant.
assistant,
HG.
higher grade assistant,
as higher grade assistant.
SDA, GA.
The husband of the applicant is also an employee of the LICI. Full stop. The applicant and her husband are proposing to purchase a residential flat at Guwahati by obtaining housing finance loan bracket HFL bracket close from the LIC, which they are entitled to avail as per the terms and condition of their service. Full stop. However, taking the plea of tenancy.
Husband has been given NOC.
Yeah, full stop. It appears that the husband of the applicant has already been given the NOC to obtain the HFL from the LICA.
Joint,
However,
joint loan, my lord.
in respect of the joint loan application made by him and the petitioner. However, taking the plea of pendency of WPC number 2822 of 2019 before this court, the application for NSC made by the applicant has been declined. First stop. Aggrieved thereby, the applicant has approached this court by filing the instant IA seeking appropriate direction upon the authorities. Full stop. It appears that earlier a disciplinary proceeding was initiated against the writ petitioner on the basis of show cause notice dated
My lord, page 35.
20th of November
20th.
2018, which ultimately culminated in imposition of minor penalty. These are minor penalty,
Yeah, my lord, makes a dismissal
minor penalty of
reduction. Page 50.
reduction of one bracket numerical one stage
Yes,
in the time scale of pay applicable to her cadre, unquote. Reduction by one stage in the time scale of pay applicable to her cadre. This part is under quotes. You'll find it in page 50 of the petition. And also for recovery of a sum of rupees 66,972. Full stop. The aforesaid order of penalty has been assigned in the writ petition
and it is under stay of dishonorable court.
being WPC number 2822/2019, internally on the ground that the allegation brought against the applicant stroke writ petitioner could not be proved in the inquiry proceeding.
Apart from violation of natural justice.
Apart from that, the proceedings have been conducted in utter violation of the principles of natural justice. Full stop. Taking note of this case projected in the writ petition, this court had passed interim order dated
Lordship,
3/5/2019, suspending the operation of the orders impugned in the said proceeding. Full stop. It is in such factual backdrop that the applicant has approached this court by filing the instant IA. Full stop. The stand of the LIC authorities is available in the affidavit filed in IA 254 of 2023, whereby they have relied upon clauses 2.2 bracket numerical 1 and bracket numerical 2 of a circular dated 3/11/2016 to contend that there is a policy decision of the authorities at the highest level not to entertain NOC for from such employees whose cases come within the ambit of the aforesaid clauses. Full stop. It is on such count the authorities have not issued the NOC to the applicant till today. Full stop. Now, Mr. Barbara, as senior counsel for the applicant, on the other hand, submits that even if the order of penalty is imposed upon the petitioner and the writ petition is eventually dismissed, even then, she would continue to remain an employee of the LIC, and therefore her right to avail NOC for housing loan cannot be permanently declined by the authorities. More so when the applicant has enough
terminal benefits.
terminal benefits to meet the amount of housing loan sought by her. Full stop. Mr. Barbara has further argued that clauses 2 bracket Roman 1 and Roman 2 would have no application in the facts of this case, and therefore the stand of the respondents is wholly arbitrary. Stop. I have considered the submissions made by learned counsel to both the sides. Since the resistance offered by the LIC is almost entirely on the basis of clauses 2.2 bracket Roman 1 and Roman 2. The said clauses are extracted herein below for ready references. You just double tick in page 8 of the IA. Full stop. A careful reading of the aforesaid clause does not indicate as to in what manner the same would have any bearing in the facts of the present case. There is no allegation of fraud against the applicant.
No, my lord.
There is no allegation of
No, my
fraud
lord. There is a criminal case, somebody else is arrested.
against the applicant, nor is there any vigilance case pending and or initiated against her. First off, it is correct that there is an order of penalty imposed on the applicant, but the said proceeding, but the said issue is sub judice before this court. First off, a case pending before this court cannot be termed as a vigilance inquiry or an unconcluded action initiated against the applicant. Full stop. The learned counsel for the respondents has also not been able to deny the said assertion of the applicant's counsel. If that be so, this court is of the unhesitant opinion that there is no justifiable ground for the respondents to decline the NOC as sought by the applicant in the facts and circumstances of the present case. In view of the above, the prayer made in the IA is hereby allowed. The respondent numbers, who will do it?
Respond number, my lord, 1, 2, and 3.
Respondent numbers 1, 2, and 3 are directed to consider the application submitted by the
1, 2, and 3.
applicant seeking NOC for availing housing loan
Issue NSO.
within a period of 4 weeks from the date of receipt of a certified copy of this order, and process the same in the light of the observations made in this order. Full stop. With the above observation, this IA stands disclosed.
My lord, my actually installment is due I have been served with a notice by the builder. Actually, it is going to expire, my lord. Another,
But they will need a little
yeah,
time.
maybe within 2 weeks, my lord. All the
Make it-
officers are here, my lord.
3
LIC.
weeks, 3 weeks. Make it
3
3
weeks.
weeks. ISL disposal and you write, register to list the read petition in the appropriate column after 4 weeks.
Apply.
Lordship, post the petition, my lord, main case in sometime in June, my lord.
After 4 weeks.
Apply.
I would like to argue the case on merit also. Obliged, obliged.
Item 3, 4 and 5.
You put this. Yes, what are these matters?
May it please,
Ah,
Lordship.
this is-
Your Lordship, this present writ petition is for seeking protection of pay. Now, the concept of protection of pay was envisaged by the government of India, wherein to attract talents which were actually lying in for people working in the PSUs, other private organizations, or for that matter, state public sector undertakings, to attract those particular kind of people, and they were getting higher pay in those particular organizations. And in government departments, they were somewhat getting lesser pay. So to attract those talents lying in those PSU, they formulated this particular scheme wherein they gave pay protection to those incumbents who were working in those PSUs to draw the same salary which they were joining in the earlier organization. Now, after this particular OM, which is at page number 55, if your lordship, there was
No, but why are you arguing this for disposal?
for this
Question doesn't arise. We'll only decide whether it should be admitted and rules should be issued and fixed after vacation. That's the only, why should we decide a fixation of pay in the admission stage?
Your lordship.
Huh?
Your lordship, this
There's no urgency in this matter.
not urgency.
Pay
Pay
protection.
protection.
You succeed, you get the pay with
Yes,
interest.
yes.
All right, we'll admit it and fix
Yes,
it.
just that, just before vacation, if I may pray, because this particular issue has been lying dormant since 2013.
Hmm.
So 10 years have actually elapsed. So if I may pray.
No, but what will happen if it is after vacation? What will happen? Nothing will happen.
Nothing will happen as such.
Let us focus on some matters where more
Yes, yes.
urgency is there.
Yes.
Mr. D. Boral, government advocate, sorry, you are appearing for the government.
No.
Then?
Private petition.
Mr. D. Boral, council appearing for the writ petitioners. Also heard Mr. S.K. Neville and CGC appearing for the respondent numbers. You have for respondent numbers?
1 to 6,
1 to 6,
1 to 1 to 4.
1 to 4. The
1 to
day
4.
the councils know in this
1 to
court
1,
who they are appearing for, we
1
will
to 4,
consider that we have progressed.
1 to 4 and 6.
Yeah,
1
4
to
and
4.
6. And Mr. A. Tadi, 2D, Learning Council for respondent number 5. After hearing the arguments that, now it appears that the central issue involved in these writ petitions pertains to plea of pay protection. First up, after hearing the learned counsel for both the sides, this court is of the opinion that the matter will require full-length hearing. As such, admit the writ petitions to formal hearing. Since the parties are already represented, no formal notice is required to be sent in the matter. Let these writ petitions be listed for final hearing in the month of August 2023.
Obliged, Lordship.
Item 6.
DLC selected, my lord. Petitioner was DLC recommended, my lord, for the post of grade 4, my lord.
Hmm.
And in the year 2012, and my lord, the SLC rejected on the ground of, my lord, it elapsed 2 years, my lord. That is the only case, my lord.
Are similar matters pending?
My lord, Dorsey may kindly have a look, page 25, my lord. The SLC has rightly rejected his case, my lord.
Page 25.
25.
Hmm.
Just below the table paragraph, my lord.
Yes.
Married, my lord. Further, 79 candidate could not be recommended by the SLC for appointment on compassion ground due to non-availability of further vacancies, and also 2 years have already elapsed from the date of application in their case. The SLC therefore, in accordance with guidelines, decided that their cases would not be considered any further. They rightly decided as per OM.
No,
my
no,
lord.
but 2 years have lapsed during the pendency of the application.
Yes, my lord.
From the filing of the application, my lord.
But why it was kept pending for 2 years?
It has been recommended by DLC on time, my lord.
That is why we have directed many cases in this category to be
division-
listed. Whether the delay in pendency or delay in filing, both can be treated with equal intensity. Suppose the party comes late, that is one thing.
Yes.
My lord.
But he files the application in time, the department sits over the matter, then to extinguish the claim, will it be correct?
No, lordship, the DLC has recommended his name in the year 2012, my lord.
Hmm.
And this is the SLC meeting of 2015, my lord.
That's
So
correct.
actually-
Why it was not considered in 2012?
2012, 2000, but it's a 2015 SLC, my lord.
That's all right.
lord.
What the court wants to know,
My lord.
why his application recommendation was not considered or and either accepted or
Yes.
rejected in 2012.
My lord.
Why did he
Yes.
have to wait till 15? The department is to be hold up for the delay,
My lord.
and you are putting the blame on him.
But as
You
per the.
you do the make the delay and you say that sorry,
My
we have delayed it, so you don't have any claim.
Because of want of
How can
vacancies,
that be done?
my lord, because of want of vacancies, his case could not be recommended, my lord.
And it should be decided in 2012.
Yes, my lord is correct.
Yes.
But as for the OM, my lord, lordship may kindly have the OM for a moment. 2015,
OM is not binding on us.
my lord. But we are deciding the cases as per the 2015 OM, my lord.
Now, there are many cases which
Many
are
cases, my
to
lord.
be grouped in 6th of June, I think matters.
Yes, my lord.
This
the
will
dub-
also go in that category, that bunch.
My lord.
Heard Mr. H. K. Das, Learned Counsel for Writ Petitioner, also heard Ms. M. D. Border, Learned Standing Counsel. You have
Lordship, I'm
government-
government advocate for 2 and 3,
government
my lord.
advocate. Assam appearing for respondent numbers 2
2
and
and
3.
3.
Mr. D. Upamanu, Learned Standing Counsel,
Health Department.
Health Department, Assam have appeared for respondent number 1. This is yet another instance where the application for compassionate appointment made by the petitioner and as recommended by the DLC was turned down by the SLC on the ground of delay. However, the delay had apparently occurred after the recommendation was made by the DLC. Full stop. There are large number of writ petitions involving similar issue which have been directed to be listed before this court in a bunch in the first week of June
June.
2023.
My lord.
Register to verify and list this matter along with those cases.
My lord.
We'll see
Obliged,
what
my
is to be done. You
My
also
lord.
make a full length argument.
My
that will
lord.
be passed on.
Obliged, lordship.
Yes,
Item 7.
May I please, Lordship?
yes.
May I please, Lordship? Instruction received, 2 weeks time required, Lordship, to file affidavit.
Had Ms. B. Chaudhary, Learned Counsel for the petitioner, also heard Ms. S. Barua. Learned, your CGC here? No.
No.
Government Advocate Assam
For all
submits that,
respondents.
appearing for the respondents who submits that instructions have been received and therefore 2 weeks time be granted for bringing the same on record in the form of an affidavit. Prayer allowed. Let this matter be listed again after 3 weeks. Along with the affidavit. Eh?
A date may be
You
fixed.
count it 3 weeks from today. That's the date. It'll come after 3 weeks.
Enter into.
May I please, your Lordship.
Yes.
Lordship, in this matter, we have filed our affidavit today, Lordship.
Lordship, we have received the affidavit today, Lordship.
Hmm.
Next week, Lordship, may list this matter. Detail affidavit.
You don't want to file rejoinder.
No, only thing is, Lordship, in this case, they have filed an affidavit stating that they will file a details affidavit subsequently. They have
If
to file the
necessary.
affidavit, not details or anything.
No, that, whatever affidavit is, that is final. No details. Has the court given you that leave?
No.
You can't decide. You will write this much now, later on. That will be the affidavit, but you don't want to file
No,
this.
I will
rejoinder.
file details. Because of the Lordship, details affidavit, that is why I am paying.
All right, you don't want to file.
Lordship, may
rejoinder.
record, we'll file it, Lordship.
How long, how much time you want?
1 week, Lordship.
No, no, nothing will be listed before 2 weeks.
No, no,
That-
we'll need 1 week, Lordship, to file affidavit.
All right. I heard Mr. S. K. Goswami, and counsel for the petitioner, also heard Mr. C. Goswami,
C. Sharma,
C.
Lordship.
Sharma, and counsel for the respondent numbers.
All the respondents,
For the
Lordship.
respondents who submits that affidavit on behalf of the respondent has been filed today by serving advance copy upon the petitioner's counsel. Mr. Goswami has confirmed receipt of the same, but seeks a week's time to file rejoinder. In view of the above, let this matter be listed again after 2 weeks by tagging the affidavits with the record of the case.
Lordship, we record that they cannot file a detailed affidavit again, Lordship.
That's not required to be recorded. They can't do it.
Obliged, sir.
Supplementary list for admission, I can do that.
Yeah, please, Lordship. Lordship, this item has been listed in admission column. It ought to have been listed in hearing column. It has already been admitted on 28/9/2022.
It has been admitted, it's true.
Mr. Your name, please.
D. Bora.
Mr. D. Bora, learned counsel for the petitioner, and Mr. S. Vishwakarma, learned counsel appearing for the respondents.
Sole
Have
respondent.
both submitted, respondent have both submitted in tandem that this arbitration petition has already been admitted, and therefore this matter has been wrongly listed for admission today. In view of the above and taking note of the prayer made by the counsel for the parties, registry is directed to list this case for hearing
Can a date be fixed, Lordship?
after 3 weeks.
Obliged, Lordship.
For hearing, I can tell.
Wait, please, Lordship.
Yes. What is this?
I was appointed as junior engineer in Grafe Miller in 2016. Thereafter, by the implementing order, the notice of termination was issued to me, giving 1 month's time for my termination on the allegation that while being appointed, my lord, I suppressed the fact that I was implicated in a criminal case, my lord. There was a separation on my part, and therefore,
You
1
have
month.
suppressed it.
No, my case is that from record, I'll show, my lord, I had no knowledge about this. I have enclosed documents to show, even the order sheet of the court, my lord. First thing. Second thing is that even if assuming for the timing that I suppressed it, Honorable Supreme Court has laid down in of the Avtar Singh's case, my lord, on considering all other cases. In a full bench, it is considered, it has given a detailed guideline of what are the factors to be considered. In a case when it is a separation, in a case when there is a conviction, even in a conviction that is suppressed, ipso facto, I do not become ineligible for public service, my lord. The nature of offense, my age, how it is relevant to my service, considering everything, the authorities have to take a decision. So my second contention is that, my lord, nothing has been considered in that way, my lord. Avtar Singh has been relied in a second recent case, my lord, 2020, and I have the decisions with me, my lord, I place before lordship, my lord. So my contention is twofold, my lord. First thing, I did not know about this, my lord. When I came to know immediately last, and in a criminal case, my lord, finally, I have been acquitted in a manner, my lord. The prosecution witness, the complainant, they have said now FIR have been filed at the instigation of the villagers, my lord. And nothing that has been nothing was done with us, my lord. On that statement, my lord, acquittal has been given. It was a altercation with neighbor, my lord, only. And charges were, my lord, all like 323, 504, and 506, my lord. 1 year, 2 year punishment, my lord.
Okay, how, we will be able to conclude it today?
May not be, my lord. I have to rely on this judgment and all like.
Then should we fix it day after tomorrow?
Well,
Well, there is not much time left today. Had Mr. B. Chakravarti and counsel for the petitioner, also had Ms. B. Sharma, and CBC appearing for the respondents on the request of learned counsel for both the sides. Let this matter be listed for hearing again on 11/5. So you take back the judgments and you can give it